Good morning. Are you Kenneth Bartol?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Your Honor.
I am going to first also, I think we've probably done it, but just to make it clear, I'll take judicial notice of the court's file. In each of the cases, Mr. Barthol was evaluated by Dr. Capon for competency to stand trial. And we received an evaluation and report back on November 3rd of 2025. The finding in that is that Mr. Barthol was competent to stand trial. Is there any other evidence with regard to competency today?
No, Your Honor. No, Your Honor.
All right, then based on that, I will find that Mr. Barthol is competent to stand trial and proceed. So, Mr. Barthol, in cause number 25, DCCR 1207, you're charged with the third-degree felony offense of obstruction or retaliation from July 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Mm-hmm.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR, that's a state jail. Are we going on count one only in the state jail case?
So is that?
1752.
Yes, Your Honor.
Give me just a minute. In 25 DCCR 1752, the state has elected to proceed on count one only. It alleges you committed the state jail felony offense of possession of a controlled substance from January 11th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then lastly, we have cause number 25 DCCR 0878. And in that case, you're charged with a third-degree felony offense of obstruction or retaliation from May 24th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all three cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted. Is there any, again, there's no other evidence about competency. All right, Mr. Barthol, I'm going to find in all three of your cases that you entered your pleas of guilty freely and voluntarily. Find, again, you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 25, DCCR 1752, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1207, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
One guilty plea may close a case, but every decision shapes the future. In court, accountability always comes before second chances.
Also find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to go back real quick because I think I failed to mention, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Okay. These cases will run concurrently, which means together at the same time. I will sign dismissals as part of this agreement in cause numbers 25 DCCR 1206 and 25 DCCR 1208. I'm handing you in each of your cases the trial court certifications. That shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Tyree Hartley?
Yes, ma'am.
And this is 25 DCCR 0842. Mr. Hartley is charged with aggravated robbery. And what is the announcement?
Your Honor, this case, I think it's best that we move it to the trial docket. There's still some discovery that I've requested from the state that I don't have yet. I know they're working on that. We have discussed a resolution. We're not close, and I don't think the additional discovery is going to impact Mr. Hartley's decision to pursue a trial at this point based on what he's told
What,
me.
what are
But
we
Judge,
waiting
per
on?
the standard process of this court, I would respectfully ask for a final announcement setting to allow for the compilation of that discovery. There was some stuff that Mr. Wilkerson specifically requested that Ms. Mayfield was able to get with VPD and find. We'll get that to him. There's also things this case extended out of this county, so I have reached out to detectives on task force outside of the county to get stuff from other agencies, which takes a little bit longer than just going across the street to VPD to get it and be able to get him all of that. I agree with him that we're not anywhere close. He wants a non-aggravated, low pen time offer, and I'm upwards of 20+ years, especially with his jail reports that keep piling up daily. So I would ask just for a short standard reset to allow me to get all that to him and then do a formal rejection of anything.
So, Judge, I'm sorry, I didn't mean that. So this was a case that I was appointed on after a formal rejection was done.
Correct.
So,
So the rejection was just in December, and you had some time to go through it, obviously found some things you need. I'm not inclined to put it on the trial docket without the discovery complete. And so I will do one last reset. This will be the final reset for an announcement. Once Ms. Malfino gets you all the information that you've requested, you can go over that with Mr. Hartley. If nothing changes, then at that time, we will put it on the next available trial docket. As everybody knows, we don't have any kind of backlog on trials. We can get it tried very quickly. So we'll do this last one. You can get everything and then we'll go from there. All right.
yes, Your Honor.
Mr. Hartley, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Excuse?
Yes, sir.
Thank you.
Good morning, sir. You Robert Trahan? And Mr. Trahan, and clause number 25 DCCR 1094. You're charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. The indictment alleges that you were previously convicted of accident involving injury or death, a special degree felony, October 16th of 2017. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, October 17th of 2022, and also possession of a controlled substance, October 17th of 2022. And so that special degree is considered, have y'all done any research on how that's considered as far as enhancement purposes?
I believe it's considered a third for enhancement purposes. Third, I got him at 2 to 20. because-
No, just Right, if that's considered a third or more.
It's not.
then
Justice isn't about emotion. It's about responsibility. Every choice has consequences, and every courtroom decision reminds us that the law always has the final word.